of Tennessee is now in session.
Good morning and welcome to the Tennessee Court of Appeals. We want to, first of all, tell you how much we appreciate both each one of you as well as your clients agreeing to participate in this Zoom oral argument. As I mentioned earlier today, it's not the way we'd like to be doing things, but it's the safest way to do things right now. And also, it is a method for us to continue to work these cases through the appellate system, and we appreciate you participating. Since we are depending on technology to make this work, in the event that we have any technology glitch, and that very well could occur because the weather in West Tennessee is a lot worse than it is in East Tennessee today. So if we do have a problem, we'll just pause for a minute and we'll figure out what we need to do to make the technology work and make the oral argument continue. Both of you are experienced practitioners. You've been to Court of Appeals before. We will follow the same rules, the same procedure, and we'll assume that we are all in the courtroom together as we conduct this oral argument today. Each side will receive 15 minutes to make its oral argument. If you're the appellant, you've reserved any rebuttal time with Mr. Hibner, you'll receive that rebuttal time. Before we start, though, I want to be sure and introduce your panel for today. Your panel is Judge Arnold Golden from Memphis, Judge Karma McGee from Savannah, and I'm Steve Stafford from Dyersburg. Mr. Hibner, anything else we need to take up before we call the case?
No, Your Honor.
All right, you may call the case.
Brenda Naldrett Johnson versus Gary Lee Johnson.
And we'll hear from the appellant.
May it please the court, the appellee, Miss Brenda Johnson, was married to Mr. Irby Lee Johnson. They filed for a legal separation in the Chancery Court. They got that legal separation. They entered into what was a marital dissolution agreement that became part of that order for their legal separation. In that marital dissolution agreement, it had that Miss Johnson forego any right to inherit any property for Mr. Irby Lee Johnson. So therefore, it is our argument, and it was our argument in front of the trial court, that Miss Johnson did not have standing to bring a suit against my client, Mr. Gary Lee Johnson, their son, to set aside the deed that he did with the power of attorney. Being that the marital dissolution agreement became verbatim part of the legal separation order, therefore it was an order of the court. Regardless of what the parties did after that, they never came back to court to avail themselves, modify, or change that order in any way. So therefore, it would continue to be the order of the court, and she would have foregone her right to inherit, and therefore did not have standing to sue my client over the deed to be set aside.
These parties were never divorced, were they?
They were not. They continued with the legal separation agreement. There's nothing in the record that tells us why they didn't move on to divorce, but it's my feeling that if you look at the marital dissolution agreement, it had something to do with her being able to keep her military insurance, or they would have got divorced, I believe.
What didn't they reinstate the marriage, and they were living together at the time of his death?
That was disputed. They did cohabitate on and off, but they never did go to the court to modify the order in any way, nor was the legal separation ever dismissed.
You say it was contested that they moved back in together?
My client says that they were on and off moving back in together. He said they never stayed together right on, but they were together when he passed, I believe. But he says that they never did fully get over that his time that year, I think, when they had the legal separation. And like I said, they never did go in and dismiss the legal separation, nor did they ever go to modify the terms or get divorced. So our argument is that as is a order of the court, never been modified, it is, and never been changed. So she would still not have the right to inherit, nor to the standing to come to court and set aside a deed.
The will that was present, well, it wasn't presented, but what would the contents of the will, was that a will that was drafted while they were before the separation or after the separation?
I believe that was after the separation, but I've never seen an executed copy of that will.
But the son apparently had seen the will. Is that correct?
He testified that he hadn't. I can't, I can only tell you what he testified to.
And but Mrs. Johnson indicated that she had shown it to him.
She did. She testified that him and his, I guess she's a girlfriend, had saw the will. They both denied that.
And his son testified that he knew he had seen the will.
No, the son
testified that there was a will.
Yes, he said that there was a will, but he hadn't seen it.
What did the court credit Mrs. Johnson's testimony on that?
The court found her to be credible on that. The court, I believed that they had saw the will, but as far as the will goes, there was never an executed copy, never probated, and Miss Johnson herself filed a small estates without the will. So we would argue that the will is immaterial to this case.
All right. Go ahead.
I think Judge McGee might have had a question.
I'm sorry.
Mr. Stout, did the
Yes.
parties, other than this purported will, did the parties take any other steps to in any way alter the status of their property holdings after their legal separation?
I believe some of the other properties that they did put her name on, I believe. But this particular property we argued was different because my client testified that he helped his father build this property and it was always intended to go to him. There's also a dispute as to when Mr. Arbery Lee Johnson actually became unable to handle his own affairs. My client says that he doesn't believe that he was in a good state for several years.
The deed to the property that's in question here, the deed to this property was never altered or affected after the legal separation. Is that what the record shows?
It always stayed in Mr. Arbery Lee Johnson's name. And also I think the legal separation gave it to him. So it was never altered or changed in any way. They never came back to the court. It's our argument, like I said before, that she just didn't have standing to file this lawsuit.
And the parties never entered an order of reconciliation or anything of that nature?
They did not. The only thing to do with the marriage is this legal separation, and it was the final order and stayed the way it was. And like I said, there's nothing on the record to indicate it. But if you read the marital dissolution agreement, it's something that I would have crafted to help Miss Johnson keep her military insurance, because they were both, older when this happened. As far as the record, my client or my Mr. Wright was saying the record wasn't complete. I put it together as best of my memory, and the only thing the court needs to make this decision is in the record. You have the legal separation order, you have the marital dissolution agreement. If Miss Johnson doesn't get past standing, she doesn't get to the rest of this case as to whether there was undue influence or whether he self-dealed with the power of attorney or anything like that. So we would argue that we have everything before the court that the court needs to correct the error of giving Miss Johnson standing. Also, he cited some cases. There's some cases he cited where the people have filed to amend their marital dissolution agreement and other things like that. But he hasn't brought up any cases to where the court said your order doesn't count. If you enter into an order and you don't go back to the court to change that order, if you change your way you're doing things, I think you do so at your own peril. Because at any time, one of these parties could have come in and said, hey, I want to file a motion for contempt because he's not done what he said he would do in the order. And these were all agreed and put down before the court and complied with properly and to be final. I'll entertain any questions. That's our total argument on.
All right. I see no questions. We will hear from the appellee.
Thank you. May it please the court. My name is George Wright, Johnson County Bar. I represent Brenda Naldrett Johnson, the appellee. Our first response regarding the standing issue is these parties did enter into a legal separation. And subsequent to the legal separation, they really never separated. They resumed living together. They actually executed deeds which undid the deeds they did pursuant to legal separation. They executed and put them back exactly the same way as they were prior to the legal separation. They were
Mr.
never.
Wright, did they ever execute a deed as to this property?
No, because this property was in Mr. Johnson's name only prior to the legal separation agreement, and it was just left like it was. That's what they intended. And as far as the record goes, appellant didn't even reflect there was a record, which we have, it's 2 volumes with various findings of the court to the effect that the first time this was brought up, the response of the plaintiff at that time was that this was a contract, and it's treated by the courts as a contract. They never did get divorced. There's never been an order dissolving their marital solution, so they died as husband and wife. The failure to, I think it's obvious from their conduct that they intended to just keep living together, and it's evidenced by the fact that they put the deeds back the way they were. Then we get to the issue of the powers of attorney, and also the issue of the setting aside of the deed. And since we don't have a record, and the court during the appellate process, the court found that the appellant had not complied with the rules of appellate procedure, in that he did not have a statement of facts to referring to any evidence or testimony given. And the court said basically the best thing he could approve would be whatever the findings of the court were on these. And in this regard, I would point out to the court reviewing the final judgment and order of the court. The court found that Ms. Johnson and the defendant, Gary Lee Johnson, were the sole surviving widow and son of Irby Lee Johnson, deceased. The court goes on to deal with the fact that Irby Lee Johnson executed a durable power of attorney to Gary Johnson in conjunction with his grandson, John Wesley Goodman Johnson and Jackson Lee Goodman Johnson, for the purposes of health care and things of that nature. Approximately 3 days prior to the death of Irby Lee Johnson, or about March 23rd, 2017, the defendant had a deed of conveyance executed to him individually by him using his power of attorney. The court correctly found that that power of attorney created a fiduciary relationship, and that the defendant failed to overcome the presumption of the undue relationship by the burden of proof required, which is clear and convincing evidence that shifted to him, and that he had failed to carry that burden. Accordingly, the court set aside the deed. And in particular, we would note that the court found, these are findings of the court in the final decree, that in the final order, that they had prepared on the date, and they were relying on the testimony of Jackson Goodman Johnson, who the court found great credibility in his final order. They were relying on and found that on the day that Gary Lee Johnson or that Jackson, on the day that Irby Johnson had passed away, he and his wife had prepared and executed last wills and testaments disposing of their properties. Relying upon the testimony of Jackson Goodman Johnson, the son of the defendant and grandson of the plaintiff, he had possession of these wills and he'd read them, and he knew the contents, and he knew that the defendant, Gary Lee Johnson, was omitted from taking anything under the will. And the proof showed that the defendant and his wife then, or that's who she presented herself to be at the trial, testified that they'd never seen it, but that they did, in fact, see it, and they knew the contents. And the court found that subsequent to this, on about after I think the defendant had prepared the deed to himself, that he and his wife actually contacted Jackson Johnson, the grandson, and told him that he ought to go ahead and use the power of attorney, of which he was on as well, to have property executed to him. And of course, he said that's not right. He wouldn't do it. The only thing that was presented at trial was Irby Lee Johnson's, well, it was statements by Gary Johnson that he always understood that was going to be his property. But we simply say that overall, number one, these parties never got divorced. The relationship of husband and wife has never been destroyed or done away with. And the parties subsequent to their separation agreement redid everything. And they really never did, in fact, cease to reside as husband and wife. These were all findings of the court in its final order. And we're saying that in the absence of a record, the Court of Appeals really has nothing to go on to reverse the chancellor's finding. And that's our first argument, is that we're asking the court to uphold the chancellor's ruling and reaffirm it. And then we're asking that the court find that this is a frivolous appeal and remand it back to the Chancery Court for determination of attorney's fees and any damages that my client may have suffered by reason of this. And we realize that the frivolous appeal is not something that's easily granted or easily taken advantage of. But we feel, as we stated in our brief, that we have met the burdens of the statute for frivolous appeals, in that, number one, there was never a record presented or taken or anything. Number two, the issue appealed from was fully dealt with at a previous hearing, was not even raised on, the final hearing, but, and we realize that Mr. Stout can appeal that as well, which is what he's chosen to do. But we're saying that it really meets the standard of, in and of itself, the fact that these parties were never divorced. That precludes the finding that they're obligated under a written marital dissolution agreement. But the parties subsequently acted as, and they did. They never intended to get divorced. They lived together. The court found these things, and they found that they had, in fact, executed wills that Mr. Gary Lee Johnson, the defendant, had actually seen both wills and shown to him. And then my client testified at the trial that, well, after she they gave her the wills back. She put them in her place, and then they were subsequently just gone, missing, not to be found. The court found that there was a conversation between Gary Lee Johnson and his son, the grandson, to the effect that he ought to take this power of attorney and use it to transfer property to him, which of course he didn't do. And but the fact that there was no record of this, there's no basis, we think, for the court to reverse the chancellor's finding on that basis. And we think we've met the requirements of TCA 27-122, which is a frivolous appeal statute. And we've cited a case that it's up to the appellant to provide a record for the Court of Appeals, and that the fact that there was never a record even presented to is something the court can consider in adjudicating a frivolous appeal. And so we're asking that the court affirm the ruling of the chancellor on the primary issue in this case, that the court find that this is a frivolous appeal, and that the court remand it back to the Chancery Court for assessment of attorney's fees and damages, which may have been suffered by my client as a result of this. Thank you.
Mr. Wright,
Yes.
did your client ever attempt to probate a lost will?
No. She never attempted to, and they did. She and the defendant, Gary Johnson, they did a small estates procedure to deal with the personal property. And that was primarily to deal with that because Mr. Johnson wanted a car and money and things like that that were in the decedent's name. So they did a small estates procedure. We can only deal with personal property at any rate. No, there was no attempt to probate a lost will. It was just lost. And the court found that he apparently died intestate due to that circumstance. So no, there was no attempt to probate a lost will.
Thank you.
All right, we will hear from the appellant in rebuttal.
Please, the court, as far as, Tennessee does not have common law marriage. So these people did not die married. They died legally separated per the order of the court, per the order that they agreed to.
Is there a significant difference between being divorced and being legally separated?
Yes. Well, being divorced, all issues are over and settled, and people are living separately completely. But if the court's going to allow a person to be legally separated.
Well, let me ask you another question.
Yes, sir.
The whole purpose of a legal separation is for the parties to continue in the married state, but define their responsibilities during that point in time. And the statutes are abundantly clear as to how a person who is legally separated may proceed on and obtain a divorce if that's what they choose to do. But until they do that, they're still married, aren't they?
They are married, but under the legal separation, they would still have to behave according to their order. Either party at any time could have came and filed a motion for contempt for not going by this agreement. I guess one could argue that they acquiesced to it, but they never did go and modify their order. So I feel like they were still under the conditions and would have to abide by that.
And what's the effect of that order upon the death of a party?
Well, if in that particular order we're talking about, they anticipated that he might die during this legal separation and put that she would forego inheritance. So I think that's accounted for. So I think that it should still be, I still think that she did not have standing to file this lawsuit. And if she doesn't have standing to get her foot in the door, we don't get into whether anybody saw the will or what happened with the power of attorney.
I have to be frank with you. I don't understand your standing argument. I think perhaps you're conflating some issues. There may be an argument about justiciability, but I don't understand the standing argument.
Okay, when the reason that the court allowed Miss Johnson to proceed with her lawsuit, because we filed a motion on this issue, and that's what we appeal on, is the court found that Mr. Gary Lee Johnson and Miss Brenda Johnson were the two heirs of Mr. Irby Johnson. We argue that she gave that up in this court order, clearly in the marital dissolution agreement that became part of the order, and that the two of them never came back to the court and said, hey, we want this changed. So if she's not an heir, she cannot file to have the deed set aside. Because once the deed's set aside, it goes to Mr. Johnson and Mrs. Johnson as tenants in common. Whereas if she wasn't an heir of the estate, she couldn't file to set aside the deed because she'd get no benefit from it. Did that answer your question, Your Honor?
You have responded to my question. No, I don't think it answers my question,
Okay.
but thank you.
That's, like I said, that's where we're attacking the order of the court. The court said that they were both joint heirs. We argue that she's not an heir because she signed that away in that marital dissolution agreement.
Okay. As
far as the Mr. Wright's Rule 24 appellate procedures that he's talking about, says that you're to prepare a record to the best of your memory and analysis. I did that. Mr. Wright objected to my recitation of the record, but he didn't offer one of his own. And so the court simply said it's the findings of the court. So we would say that the court has enough. You have the marital dissolution agreement. You have the Chancery Court giving Miss Johnson standing. We would ask that the court set that aside.
Okay, thank you very much. Gentlemen, thank you for participating in this Zoom oral argument. We will take this matter under advisement and attempt to give you an opinion as quickly as possible. Again, we appreciate you working with us today. Mr. Hebner, anything before we recess to the call of the next case on the docket?
No, Your Honor.
All right, you may recess court.
This honorable court is now in recess until 2 p.m.
Thank you.
Thank you, gentlemen.